Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and this is part 2 of the video presentation, and the topic was the concept of arbitration under Arbitration and Conciliation Act, and I'll be continuing to talk about the topic, talk about the arbitral award. So the unilateral model law does not define an award, and during the drafting of the model law many definitions were proposed, but however none was adopted as they wanted to encompass not only final awards but also partial awards and interim awards in the definition of the arbitral award. One such proposed definition under this was that award means a final award which disposes of all the issues submitted to the arbitral tribunal and any other decision of the arbitral tribunal which finally determines any question of substance or the question of its competence or any other question of procedure, but in the latter case only if the arbitral tribunal terms its decision as an award. Russell describes an award as a final determination of a particular issue or claim in the arbitration. And further moving ahead, there is no internationally accepted definition of the term award, and traditionally a distinction is drawn between an interim award which resolves an issue relating to jurisdiction and a partial award which decides a substantive issue at the interim stage. In the interim stage, the Indian Arbitration Act does not define the award by itself, and Section 31 of the Act sets out the requirements of an award. Section 31 Clause 6 confers jurisdiction on the arbitral tribunal to make an interim arbitral award on any matter with respect to which it may make a final binding award. In the case of Satwant Singh Sodhi versus State of Punjab, the Supreme Court considered the question as to whether an interim award is final to the extent it goes or has effect till the final award is delivered and stated that it will depend upon the form of the award only. And further, if the interim award is intended to have effect only so long as the final award is not delivered, it will have force of the interim award and it will cease to have effect after the final award is made. On the other hand, if the interim award is intended to finally determine the rights of the parties, it will have force of a complete award and it will effect even after the final award has been delivered. Final award is an award by the arbitral tribunal which finally determines all of the issues in dispute between the parties. Successive award is an arbitration agreement may provide for reference of disputes arising out of the contract, and there may be as many awards as there are the disputes arising out of the contract. The tribunal can make a separate awards for separate submissions arising out of the same contract. Then another type is the additional award. If on the receipt of the arbitral award a party finds that the tribunal has omitted to decide certain claims which were present in the arbitral proceedings, the party within 30 days from the receipt of the award may make a request to the arbitral tribunal to make an additional award an additional award which omitted the claims under Section 33 Clause 4 of the Act. If the tribunal considers that the request is justified, it shall make an additional award within the time limit of 60 days from the receipt of the request under Section 33 Clause 5 of the Act. So another kind of an award is settlement award, which is given under Section 30 of the Act. Now I'll be talking about the arbitral tribunal, which is given under Section 2 Clause 1 subclause D of the Act. And arbitral tribunal means a sole arbitrator or a panel of arbitrators. Article 2 Clause B of the Unilateral Model Law defines an arbitral tribunal to mean a sole arbitrator or a panel of arbitrators, and the 1996 Act verbatim adopts the definition of arbitral tribunal in Section 2 Clause 1 Subclause D. Article 10 of the Unilateral Model Law provides that the parties are free to determine the number of arbitrators, and failing to such determination, the number of arbitrators shall be minimum 3. Further, Section 10 of the Indian Arbitration Act 1996, however, deviates from the text of the Article 10 of the Unilateral Model Law. Section 10 Clause 1 of the Indian Arbitration Act talks about that that it provides that the parties are free to determine the number of arbitrators, provided such number shall not be an even number. Failing to such determination, as per Section 10 Clause 2 of the arbitral tribunal shall consist of sole arbitrator. This was the concept of the basic concept of arbitration under the Arbitration and Conciliation Act, and various definitions also given under the Unilateral Model Law, and also referring to the Indian Arbitration Act, etc. And I hope I was able to give you guys a brief picture about the topic. Thank you.